Gemalto Holding BV and others, and Infineon Technologies AG and others.
May it please the Court, I appear today for the appellant, Gemalto, with Miss John and Miss Lupakova. Miss Ford, to my right, appears with Mr. Johnston and Miss Mockford for the first and second respondents, Infineon, and Mr. Jowl appears with Mr. Bailey for the third to fifth respondents, Renaissance. May I begin with a housekeeping item, which is that it is rather warm in this courtroom. The air conditioning does appear to have kicked in a few moments ago, but there's a joint feeling on the part of counsel that if the court were to permit, we would appreciate removing our wigs.
Well, we personally don't have any strong views, Mr. Turner. We're not hot.
See if that remains the situation in half an hour.
We don't have any strong views, which means you may, if you wish, remove your wigs.
In that case, we will. Very grateful, my lord.
I have slightly strong views about screens concealing, but I suppose I'll live with it. Right, okay. Off we go.
There's a lot of hardware in this room.
There's a bit, yes.
Second point, my lord, there's an e-bundle, obviously. There are no confidentiality issues that should concern the court in this appeal. And as regards the timetable, as was indicated to the court last week by email, there's a fair amount to get through. All counsel are grateful for the court's assurance that time will be allowed for proper argument, and the court may be willing to sit until 4:30 today.
Well, we're not very keen to sit till 4:30. We've all got very many other things to do. We will make available tomorrow afternoon if that is necessary.
My lord, I'm grateful. On that footing, the plan is that I will open until 3 p.m. this afternoon. The respondents will then make their submissions and will run until 12:30 p.m. tomorrow. That will leave around half an hour for a reply, but if there isn't time...
And the order of events for the respondents is?
Forgive me, my lord, but that's not an agreed timetable. I think we anticipate that we will need a greater degree of parity.
Sorry, you've got to speak up, Mr. Jowl.
Oh, forgive me, my lord. I'm afraid that's not an agreed timetable, my lord, in the sense that we had proposed there should be a parity, a division of time.
Is that not parity?
It's not, my lord, no.
So we're not having a stop clock arbitration system?
No.
Mr. Turner's going till 3 o'clock today. That sounds totally reasonable, doesn't it?
Well, we have no problem with that, my lord, but on that basis, what we're not keen on is then being told that we have to stop at 12:30 tomorrow.
Well,
because there are two
may
of
or
us.
may not have to. Shall we see how we get?
Well, of course, my lord.
Jolly. Well, I really wanted to know who's speaking.
Well, we've agreed to divide it up between us, and broadly speaking, and I will explain that in due course. I'm happy to do so now, but I don't want to.
Well, I mean, just the characters. Who's speaking first?
Oh, Mr. Turner is of course.
No, I know that.
And then I will be speaking.
You're going first.
I'm going to go first on issue 1 on the law, and Miss Ford is going to then pick up on the facts, which is the same division as we had below, and then Miss Ford will also deal with issue 2.
Right. Okay. Thank you very much.
That's the division.
Right. Yeah.
May it please the court. The appeal concerns the application of the limitation period rules in the context of cartel damages claims. The route map for my submissions will be as follows. 1, an overview of the essential points, and in a nutshell, why we say the appeal is well-founded. 2, look at the legal framework under Section 32 of the Limitation Act. 3, very briefly at the facts. 4, the pleadings. 5, the judgment below. And 6, submissions. So I'll begin with the overview.
Now that all sounds very good, Mr. Turner, but there is one issue that bothers us, which you all need to be aware of. The case was argued by agreement on the basis that the statement of claim test applied, and that FII didn't change that, which obviously expressly it did not. But the argument in FII, arguably, is applicable to section 32(1)(b) and concealment. And if you do a close analysis of the 9 points raised by Lords Reed and Hodge, they are directly applicable to a case of concealment, and they are concerned with the proper construction of the words in the proviso to section 32(1), discover but mistake concealment or fraud, rather than the words of 32(1)(b) itself. Therefore, on one view, the judge decided the case on a wrong view of the newly found law indicated by FII. She said, by agreement between the parties, that the parties didn't think it made any difference. But on one view, it might make a difference. And I would certainly benefit, and I think all of us agree about this, we would benefit from argument as to whether anything I've said is good, bad, or indifferent, and whether there is any difference between the application of what I would term the FII test, the Lord Brown test, and the test applied by the judge, namely the statement of claim test. Because here the facts were quite exiguous, the facts available to the claimant, as no doubt, Mr. Turner, you're going to tell us. And therefore, on one analysis, the pleading of the claim would have been quite difficult and quite bare on the facts you knew when in April 2013. So I just thought I'd raise that because it's going to be the subject of questions that will come from the bench. And if you didn't know it was going to be the subject of questions that will come from the bench, you might be passing our initial thoughts like ships in the night.
Well, I'm extremely grateful for that indication and endeavour to touch on that in the course of...
But since you're dealing with the overview and then the legal framework and then the facts and then the pleadings and the judgments below, you'll be able to cover all that.
Should be. So, my lord, there are 2 grounds, and if we now try to call them up on screen, core bundle, CV, tab 2, page 1. Magnify that. First ground is essentially about the level of knowledge which a claimant in a follow-on cartel damages case must have before they lose the protection of section 32(1)(b) of the Limitation Act, or they're found to have discovered the concealment. Specifically, does knowledge that the competition authority has issued a statement of objections suffice to give rise to a reasonable belief in the existence of unlawful cartel activities when there is no independent evidence of wrongdoing beyond the Commission's investigation itself? That's the essence of ground 1. Ground 2 concerns whether a claimant can reasonably draw inferences about the period during which there were cartel activities by reasoning from the ambit of factual requests for information sent by the Commission prior to its issuing a statement of objections. The nub of the appeal on the first ground is this. It's that the judge lost sight of the test she needed to apply. Was there sufficient material to give rise to a reasonable belief that the essential ingredients of the tort were present? She referred to that test in paragraph 51 of her judgment, but her actual reasoning took a different path. Her essential reasoning, which we will come to, was that under the European system, the Commission is meant to issue a statement of objections only after an in-depth investigation. Therefore, a potential claimant can properly infer that the Commission's position does not represent mere speculation or suspicion. Rather, she said, a potential claimant can infer that the Commission's preliminary view is based on a good deal of evidence. So far, so good. And as a result of that, she said, a damages claimant is entitled to rely on the step taken by the Commission as providing it with sufficient confidence in the existence of the underlying wrongdoing itself, a reasonable belief. I will unpack her line of reasoning more closely in due course, but the judge's essential mistake is the proposition that the fact a statement of objections has been issued supports a reasonable belief in the existence of the underlying cartel infringement. One stands back. The competition authority itself, the Commission, doesn't say it has a reasonable belief in there having been an infringement at the time it issues an SO. Would never say that. The correct position is that the issue of an SO gives rise to a reasonable belief in there being a case to answer. And that is a very different thing.
Why does it matter whether there's a case to answer if FII applies, and the real question is simply whether you know enough to have sufficient confidence to embark on the preliminaries to bringing a claim? Because concealment's binary, isn't it? Either the thing's concealed or it's not concealed.
Yes. Yes, that's right. And at what point does one have a reasonable belief that the underlying thing concealed exists? Our point is that when the Commission issues a statement of objections, it doesn't consider there's a reasonable basis for belief that the infringement has occurred. That's not its process. It's that there is a case which must be answered. And so when your Lordship refers to sufficient confidence, the question is sufficient confidence in what? And we say it has to be sufficient confidence in the existence of the ingredient of the tort, the commission of the wrongdoing. Your Lordship referred straight away to the preliminaries test. I don't know if this is perhaps a moment, I may as well go there immediately, as your Lordship has raised it. If we go in the authorities bundle,
what are we looking at?
tab 25, FII.
FII,
Let's have a look at FII.
I've got it.
And then I'll resume my thread after that if it suits your Lordship.
Yeah.
Authorities, tab 25 is FII. And you go to page 88. 88, I'm sorry.
Could you just do paragraphs, because I'm looking at it in a separate copy.
Yes, it's paragraph 192.
Thanks.
So this is in the section of the judgment, and I hope this will suffice for the moment, my Lord, where the court is explaining what it means by the preliminaries test. Picking it up from the second sentence, they say the limitation period normally begins to run on the date when the cause of action accrues. It's not postponed until the claimant's consulted a solicitor, carried out investigations, and is in a position to plead a statement of claim. Actually, to plead it, pen to paper. For example, a pedestrian who's knocked down and injured by a car while using a zebra crossing has a cause of action against the driver, which accrues on the date of the accident. It will take time before they can issue a claim. He will need to consult solicitors, and counsel may have to be instructed to draft the claim. There may be many matters which have to be investigated, and that may take time. And then if you go up to the top of the page, paragraph 191, same page, you'll see that the court is referring there, third line, to what this is doing as placing the commencement of the limitation period slightly earlier than in the fraud cases. In other words, the concept of embarking on preliminaries, my submission, isn't altering the premise that a claimant needs first to have sufficient confidence, a reasonable belief, that the essential elements of the cause of action are in fact present.
So just slow that down a bit. Is not altering the premise that the claimant needs to have
A reasonable belief
in
or sufficient confidence that the essential elements of the cause of action are present.
reasonable belief that the essential elements are present.
And in the example given by the court there, that happens when the running down takes place and there is the car accident.
You use the expression essential elements. I'm looking at 195 of FII. That refers to the essential facts on which the cause of action is based. Is that?
I mean the same thing, yes. So I mean here, the agreement, the unlawful collusive agreement, which causes loss.
So the question is whether a press release about an SO tells you what the quotes essential facts on which the cause of action is based, whether or not it does tell you that.
It tells you not that they are present, that they exist. It tells you the Commission considers there's a case to answer. That's the distinction that we're drawing here. And in relation to the preliminaries...
What I don't understand is what's this got to do with Section 32? Section 32 is about discovering the concealment.
Yes, it does. Yes, it is.
It's not about essential facts. This is why I find, in the context of FII, the statement of claim test, which everybody previously thought was the law, so perplexing. Because I quite understand why everybody thought it was the law, and my own judgment in DSB, I think, waxes lyrical about it. But the point is, if it's not the law, and if all you're looking to is whether you have discovered the concealment sufficient to be allowed to be expected to go and have a look at the thing, investigate, do whatever you need to do, then that's a very different matter from having a reasonable belief, as you say you need to have, in the essential elements or facts.
I perhaps ought to, I can see I ought to develop it in stages, but essentially the answer here is that in this sort of case, the deliberate concealment is the secret price fixing itself. And the question, therefore, for the purpose of Section 32, is when it can be said that a claimant discovers that secret price fixing, which is the deliberate concealment. Returning very briefly to...
Just dwelling on that, Section 32, I suppose concealment in Section 32(1) is cross-referring to any fact relevant to the plaintiff's right of action as being concealed. So it's concealment of a fact relevant to the plaintiff's right of action.
Yes.
But your case is, and my Lord's right, of course, your case is that what's concealed is the deliberate price fixing, which is binary. Either it's concealed or it's not concealed.
Yes.
So why is it not, when you know that an august body like the European Commission thinks there's a case to answer about price fixing, no longer concealed?
Because at that stage, all one knows is that the competition authority considers that there's a case which may be right or may be wrong as to whether there's an infringement, that may be abandoned or withdrawn or narrowed.
Of course, but it's the same as a mistake. I mean, in the old days, we thought to know that there was a mistake, you had to go to the European Court of Justice, to the final court, before you could know there was a mistake. But that's been swept away by FII and says that's all nonsense and gives rise to illogical paradoxes.
Yes, I will develop this reasoning, but here, on that point, there is a difference between a commission decision and a final authoritative statement of the court.
Of course.
So in this particular context, the administrative decision of the European Commission marks their conclusion, and that can then be appealed, and often is appealed, was in this case, to the European Judicature, And the analogue to the point that your Lordship is making based on FII is the decision of the European courts on appeal from the European Commission decision, where they give finality to that conclusion.
I agree, but that doesn't answer the point I'm putting to you about the binary nature of concealment. You see, my concern about all this is it really does sort of, I mean, I'm a very common sense sort of person, Mr. Turner, and I ask, how can you say that the fact of the price fixing is any longer concealed after somebody like the European Commission has said, we think there was a cartel? We don't know, we may think, but we've got evidence that leads us to believe that sufficiently to issue something as important as a statement of objections. It's no longer concealed, it may not be true, but it's no longer concealed. Is it? Rhetorical.
Well, my Lord, I shall develop that, and what I will say in relation to that particular point is that at the time that the Commission launched its investigation, and through the point when it was investigating and issued its statement of objections, you may have seen from the written materials that one of the factors was that Infineon goes out to its customers and says, you know, we've carried out an intensive internal investigation, there's nothing to see. There's nothing to see. And so, your Lordship is definitely hitting a key point in the case, which is the meaning of sufficient confidence or reasonable belief, and whether it is satisfied by the fact that a competition authority says that there is a case to answer. Your Lordship says that deliberate concealment is binary. We agree with that. There comes a point at which it is no longer concealed. But we say that is the point at which, and we do rely on FII, a claimant is in a position to form a reasonable belief that the infringement has occurred, as opposed to saying to itself, as a reasonable party, I have no idea whether this is correct or not. And I will develop the point that at the point here, where the statement of objections is issued, the claimant was in the latter situation, not the former.
Mr. Turner, while we're on this, can I just ask you to do one thing when you do that? Can you think about your case to answer, which you put on your side of the line, in the context of the example in paragraph 192 of FII? Because I'm bound to say at the moment, the example of the road accident looks to me like a case to answer situation, which is on the wrong side of the line as far as you're concerned. I'm not asking you to answer it now, but perhaps you take that into account when you...
I'll give you an immediate answer. So that the point about the road accident is that there one knows that there has been the running down. That has happened.
Right.
So the basic fact which gives rise to the cause of action is known about, and in that case, known about directly, without inference and with certainty. Here, the question is the unlawful agreement, fact relevant to the cause of action. And that is a matter of inference. And the question in our case is when a reasonable belief in that having happened occurs. So in the case of the running down, one perceives it directly, one knows that that has happened. In the case of the unlawful agreement, secret unlawful agreement, you arrive at a point where you are aware that the competition authority considers there is a case to answer, and I'm drawing a distinction between that and knowing...
Understand?
Yes.
Just so as you understand why I asked you the question, what you don't know in 192 is that a tort has been committed.
You don't know that a tort has been committed, that's true, so that the characterisation of what has occurred is unclear. And similarly, if you take, again, the analogy of our case, unlawful agreement or concerted practice, there comes a point, and we say it's the time when the Commission's decision emerges, when you become aware that there is grounds for reasonable belief that this did happen. The addressees, the respondents here, may then appeal, say the Commission has misunderstood the evidence, has mischaracterised it, and so on and so forth. And they may turn out to be right on appeal. But that is the point which is analogous to, we say, the situation here, where you perceive, as it were, with more than your own eyes, you are the victim yourself of a running down accident on the zebra crossing.
Okay.
Now, my lord, that's our essential point on ground one, that the issue of an SO gives rise to a reasonable belief in there being a case to answer, not a reasonable belief on the part of the claimant, the third party, that there has been an infringement at that point. Admittedly, it may be the case that even prior to the Commission adopting an infringement decision, a potential claimant does have available to it various independent strands of evidence that are sufficient to give rise to a reasonable belief in cartel practices. Both the Granville case, which features in this appeal, and the Nokia case were examples of where that had happened. There were other things going on which were sufficient to give rise to a reasonable belief in the mind of the claimant that there had been the unlawful international conspiracies in those two cases. But where a potential claimant has no basis beyond the Commission's investigation for thinking that there's been a cartel, and indeed when the main supplier declares it's conducted its own exhaustive investigation following the Dawn raids and has found nothing, the fact of issue of a statement of objections means only what it says on the tin, that there's a case to answer and the parties will now exercise their rights of defence. Put differently, the fact that the Commission has issued a statement of objections doesn't entail, in our submission, discovery by the claimant of the underlying wrongdoing, the deliberate concealment, sufficient to mean that it loses the protection of Section 32(1)(b) of the Act. Turning to the second ground of appeal, the point here is slightly different. It's common ground, and it's clearly established in the case law, that a claimant must have the requisite knowledge of each of the essential ingredients of the cause of action for it to amount to discovery of the concealed wrongdoing, and that there's no need to discover or gain knowledge of further facts. In a cartel damages case, one of the essential ingredients is the time period when the cartel was practiced, causing loss. And a claimant in this field typically pleads that a cartel was operated at least from date X to date Y based on some material. But in this case, all there was to go on was the contents of two factual information requests which had been sent to Gemalto by the Commission in the months prior to the statement of objections being announced. And the judge's reasoning on this is short. She states that reliance on the time period in respect of which questions have been asked at the information gathering stage do involve drawing an inference. That is so. But she says in most standalone cartel claims, it's likely to be inevitable that one draws inferences. We do not question the principle that a claimant in this field may draw inferences. The issue is whether the material here is a proper basis for drawing these particular inferences. You'll see in the judgment that the judge does not deal with that, and there's no good answer to it from the respondents. And that includes the new point which is introduced by paragraph 64 of Infineon's skeleton, contending that under European law, the issue of an information request itself suggests that an infringement has been committed.
I don't think that can be right, can it? RFI is an RFI, it's a request for information. They're often issued simply by the Commission to collect information, and in this case it preceded the SO, so it can't have a higher status than the SO, which itself is a statement of objections subject to rights of defence. It's just simply a request for information. You don't know what's in the Commission's mind when it issues it.
My Lord, that's our position, and we've responded on the legal point in paragraphs 42 to 49 of the supplemental skeleton. The respondent's overall position on this second ground seems to be that provided it is not, quote, wholly speculative to draw an inference from the terms of the Commission's information request, that will do. It will be a proper basis for asserting a reasonable belief in cartel practices during the period in question, or put differently, for saying that one discovers that those practices occurred in that period. And their approach here is to take as the touchstone for reasonable belief whether a pleading which includes such an allegation would be liable to be struck out as having no real prospects of success. If we look, for example, at Infineon's skeleton argument in the core bundle, please, tab 4, page 24.
Sorry, can you give paragraph?
Yes, I apologise. Paragraph 65C. Go over the page to page 25. You'll see that Infineon is saying that essentially, provided that a claim is pleaded in this way, then it is a viable claim. And we say that the question of reasonable belief on the claimant's part is not coterminous with whether a pleading is liable to be struck out as fanciful and unrealistic, because those are not addressing the same thing. And this is where the true analysis of the statement of truth authorities, which were introduced by Infineon in its skeleton, come into the debate today, because a party should not bring a claim unless they have an honest belief in the truth of the facts pleaded. And as Mr. Justice Foxton pointed out in the Granville case, when you translate that principle into the context of Section 32 of the Limitation Act, which is about objectivity and reasonableness, you have to take an objective stance and essentially ask whether the available material, we would suggest, is sufficient to support a reasonable belief in the pleaded allegations or not. That would be how one looks at the statement of truth condition from the perspective of an objective approach. If the position is that a reasonable claimant who's got access to that material would say it still leaves them with no idea whether the allegation is true or not, that's the test in the Berry Piling Systems case, then that's not good enough. And it is the case here, both in relation to ground 1 of our appeal, which concerns the significance of the knowledge that an SO has been issued, and in relation to ground 2 of the appeal, which is about whether you can infer cartel behaviour during a particular period as the result of receiving a factual information request from the Commission some time before.
I mean, I see all that as entirely logical if the statement of claim test is the right test. I don't see it as entirely logical if the question is whether or not you have discovered a concealment. And that and if you remember Lord Reed and Lord Hodges' reasoning,
yes,
one of the things they say is that by comparison with the question of whether or not you reasonably ought to have discovered, you then look at the question of not whether you actually knew, but you assume that you're somebody who wants to know whether there was a claim. And in other words, that the trigger has been triggered. And so when you're asking yourself, do you have a reason, when you're saying as your submission, you must have a reasonable belief in the claim, otherwise you can't bring the claim. That's all to do with whether or not you complete a statement of claim, not whether or not you've discovered, or could with reasonable diligence have discovered, the concealment.
yes,
You have to assume that you want to bring a claim. The question is, this reasonable belief stuff is simply originates from the objectivity of the test. It's not a sort of mantra in itself, but you're applying it to the whole substance of the claim, whereas Section 32 is simply about whether you've discovered the concealment. Neither more nor less. That's why FII is so important, because it's saying you do discover if you've got the ability to investigate. And so that's why I think the whole shift of this case has come from the wrong angle.
Yes, let me try to deal with that. I'm sure the point may arise again as I go forwards.
Well, I'll try not to make it.
No. But it's extremely important to appreciate that point and try to grapple with it head on straight away. We see the FII test in the following way. It's not saying that one waits until one has all the material that one might want in order to actually plead a statement of claim. So in this particular case, when one learns, or we would say gains sufficient knowledge that there has been an unlawful agreement, still there's a lot of work to be done on the claimant side. You need to work out who bought from it, which entities, whether there's an international development, an international dimension to be considered, because in an international conspiracy you need to work out what the supply lines were. These are the sorts of investigations that in this area one needs to undertake before one is in a position to plead the claim itself.
So you accept, do you, that the FII question is the one you ask, namely, have you got sufficient information to start investigations?
Yes, in this sense, to start investigation of the matters that one needs in order to actually plead the claim itself, in particulars. But to start investigation is something that I need to focus on specifically, because to start investigation, we say, does not mean we now learn that the Commission has opened an investigation and is carrying out its own process. We will start fishing because we're interested in order to ascertain the same thing that the Commission is looking into. What it means is that once one has obtained a reasonable belief in the essential facts of the infringement or the essential concealment, here that there was an unlawful agreement, once one knows there's reasonable grounds for believing that, then there's a range of things to investigate.
But how can't there
procedurally
be
before
grounds?
I'm sorry, not before one.
How can there not be reasonable grounds for thinking there's been a cartel when the European Commission says it's investigating a cartel?
Because all that means is that the Commission considers that on the evidence it has gathered there is a case to answer.
Yeah, reasonable ground.
No, my Lord, with respect, not.
Not reasonable.
Because the Commission itself would never, if one thinks of it from their perspective, they would never say, we have amassed this evidence, we have put it together in the statement of objections, and we believe, or we have a reasonable belief, in an underlying infringement having taken place. That's not the way that this process works, because it is fully recognised that what they have put together as the outsiders, as the competition authority, may well not be correct.
Course, but it's one-sided. It's like a statement of claim. A statement of objection says, this is our evidence, there may be an answer to it, please tell us, which is exactly the same as a statement of claim. It says, this is our case, you may give disclosure and have lots of additional facts we don't know that provides a complete answer to it. But it still means you've got reasonable grounds for asserting the claim. That's the point. And so the idea that you can say there is no reasonable grounds for thinking there may have been a cartel when the European Commission has set out the case for a cartel seems strange to me.
Well, my Lord, we say that reasonable belief in the existence of the underlying cartel means that you think that it is essentially something that is likely to have happened rather than something where you say to yourself,
It's got to be likely.
well, reasonable belief means that a reasonable person must say, not that I'm certain that this has happened, because the cases make clear that certainty arrives with a judicial decision, but that I believe, not that this may have happened, that there is some evidence rather than mere suspicion, but it has to pass a threshold of substance. There has to be something that tips the balance to make a claimant consider that this is something that not just may have happened.
I mean, that's
But-
where we come back, you see, to my question to you about binary nature of concealment. Because you are now engaged in a balancing exercise like an Order 14 situation of, is there a case, is it a good enough case to pass this threshold, blah, blah. But that doesn't look like the right test to me under Section 32, which is simply asking, have you discovered the concealment? Right? And if the Commission thinks there might have been a cartel, then at least you know there might have been a cartel. That's all you need to know. Because thereafter, like a road accident, like my Lord says, there might have been a cartel. I might have been injured by negligence. I might have been injured because I stepped out in the road like a stupid person and fell under a bus. But, you know, and then there's no tort and no claim. But you don't know, that's the analogy that the Supreme Court drew.
My Lord, again, to pick up that analogy with the road accident, there it's the running down that takes place on the zebra crossing. That's the essential fact, regardless of the characterisation and whether it turns out to be a good claim, or as their lordships say, it occurred because somebody ran into the road. Here, the essential fact, which is the analogue, is the collusion. Was there collusion between independent parties on the market or not?
Do we need the collusion? Do we not accept what you accepted earlier, which is the essential fact is that there was a cartel? Binary, was or wasn't.
Well,
you know, the details of the cartel you're obviously not going to know at this stage. But the question is, you say you've got to have a reasonable belief that was a cartel, which has to reach quite a high statement of claim type threshold. I'm questioning whether that's not the old law.
Yes. Perhaps I ought to develop this systematically, but the essential point is that here, the cartel is the collusion that took place.
Yeah, okay.
It was secret and so it was concealed in that way. And so the question is, when does one discover, to use the language of the statute, that concealment? When does one discover the underlying collusion? Now, we know that the European Commission, when it issues a statement of objections, says there is a case to answer. And my submission is that that is not the same as the claimant forming a sufficient reasonable belief that there has been collusion, which is the essential fact stripped of the legal characterisation, and before the other investigations that somebody has to go through before they can properly plead the claim itself. The point in FII being the court draws attention to that time period needed between first realising with sufficient confidence that there has been the collusion, to simplify it, and then finally being in a position to plead the case, which may only occur sometime later.
So my Lord, concealment's on a scale, isn't it? You can have complete concealment, which is what happens when the cartel is operating in secret, in a clandestine fashion. You can have partial revelation when the Commission issues a press release setting out the bare minimum but does not disclose the SO. You could have complete transparency if the defendant or the Commission issued the SO, which gave you the full particulars of dates, agreements, duration, products, etc., meetings. What you have here is something in the middle of that. You've got the revelation of something in a press release. And the question in law is whether the revelation of something is sufficient. I mean, the facts really can't be materially in dispute here. We've got the press release, we know what it says, we know it uses tentative language. The question in law is whether that triggers time.
Yes, that's right. There's a distinction, we say, between what facts one has to be concerned with in the discovery test, which we talked about, and for simplicity we will say the underlying collusion itself, which you didn't know about because it was kept secret. And second, the level of knowledge, which I'm picking on Mr. Justice Foxton's expression, that one needs to have in order to trigger the application of discovery. Yes, discovery in section 32.1. My Lord, in view of the time, I'm going to turn now to the legal framework because I apprehend that now, as I glide through, I'm going to be covering some of the points that we have helpfully debated so far.
Right.
And that will enable me more efficiently to pick up the points as we run through. I'll go to the legal
Is that a
framework.
polite invitation to us to shut up?
No, not at all, my Lord. It's extremely important to hear the court's views. The text of section 32 is at Authorities, tab 45. Go there, please. On page 5, Authorities, tab 45, page 5.
Sorry, which authority is it?
If you have it in the, if you're looking at it in paper, it may be in your fifth
No, I'm
bundle.
not looking at a newspaper, Mr. Turner. What's the case you're going to?
I'm going to the statute, section 32.
Oh, sorry. Just for some reason on the electronic bundle we don't have tab numbers.
Indeed.
Okay, I'll find it. Competition Act.
Should be the Limitation Act.
Limitation. Okay, got it. Thank you.
And if we go on that to page 5, please.
I see what you're looking
On page 5, you have the text of section 32.1b, and it provides that where any fact relevant to the claimant's right of action has been deliberately concealed from him by the defendant, time does not start to run until the plaintiff has discovered the concealment or could with reasonable diligence have discovered it. Now, in the present case, we're concerned only with the time of actual discovery by Gemalto of facts relevant to the cause of action. And the first legal proposition is that the operation of a secret cartel, contrary to competition law, in principle, will amount to deliberate concealment from the victims within the meaning of this provision. This was crisply stated by Lord Justice Males in the recent OT Computers case, the appeal from Granville in April last year. You see that, please, if we turn up Authorities, tab 27.
Are you able to use the electronic page numbering in the bundle? Rather than tab numbers that we haven't got.
So I shall. So I have it at. You should have it on page 10.
Page 10. That's. I would have thought
It's
that
835.
835. Thank you.
I see.
The problem is that the automatic bookmark.
I see. No, I'm using the Opus pagination on the bottom right.
Right.
But you see the relevant paragraph there, paragraph 18. I hope. First 6 lines. Lord Justice Males, it's in the nature of an unlawful price-fixing cartel that it's deliberately concealed from its victims, and in any event, operating such a cartel amounts to deliberate commission of a breach of duty in circumstances in which it's unlikely to be discovered for some time, which is section 32.2. Accordingly, the section was engaged and the running of time was postponed until such time as, in that case, OTC discovered the relevant facts or could with reasonable diligence have discovered them, have done so. So we are squarely in the territory, at least, of section 32.1b. We have an unlawful price-fixing cartel, and that amounts in principle to deliberate concealment from the victims. The question then turns to how one approaches this provision, how one understands the reference to discovery and what it entails. Should one treat Section 32 as an exception to the ordinary running of time against the claimant, and should you construe it narrowly against the claimant? Should you pay regard to the public interest in finality of litigation and lean in favour of the defendants on that account too? Superficial reading of Infineon's skeleton might suggest that those principles of interpretation are appropriate. If you turn that up, please, Infineon's skeleton, paragraph 19, which you should have in your core bundle, tab 4, page 8. Core bundle, tab 4, page 8. Go to the foot of the page. There's a reference to the proper approach to section 32(1)(b). And if you look at that and turn over the page, you will see subparagraph 1 indented and in italics. Section 32(1)(b) is a provision whose terms are underlined to be construed narrowly rather than broadly. See Lord Justice Rose in Johnson. It has in fact been made crystal clear in the recent Court of Appeal case law that those two propositions are not correct. If you go please to the Court of Appeal's judgment in Canada Square, that's at tab 26 in the authorities bundle electronically. Canada Square concerned the interpretation of section 32(1)(b), and that was delivered in March last year, only a few weeks before the OT Computers decision. And the panel included the Chancellor, Lady Justice Rose, who gave the lead judgment, and also Lord Justice Males, who then gave the lead judgment the following month in OT Computers. If you go please in Canada Square to page 22,
Can we have a paragraph?
paragraph 28, you'll see the judgment of Lady Justice Rose. She describes the aim of the section that we're concerned about. The aim of section 32 has been variously described as intended to ensure the limitation period doesn't bar a plaintiff whose ignorance of the relevant facts is due to the improper actions of the defendant, or as describing a situation where if the defendant isn't sued earlier, he's only got himself to blame. So there's a dual purpose. The first looks at the perspective of the claimant, the second looks at the perspective of the defendant, reflecting the fact that if they're not sued earlier, they have only themselves to blame. In the following two paragraphs, 29 and 30, Lady Justice Rose goes on to conclude that the proposition that section 32 should be interpreted narrowly, on the footing it's an exception to the running of time, could not be accepted. She explains that. If you can now turn forward, please, to paragraph 167 in the same judgment on page 62 on Opus, and magnify the bottom of the page. Lord Justice Males made the same point in slightly different terms at paragraph 167. First steps to identify the facts which are relevant to the claimant's right of action. Phrase that Lord Justice Green rightly put to me. That expression has been narrowly interpreted to refer to a fact without which the cause of action is incomplete. See Arcadia. So here that would include, among other things, the fact of the collusion itself. It's in accordance with the statutory purpose that there should be such a narrow interpretation. If the claimant can plead a claim without needing to know the fact in question, there's no good reason why the primary limitation period shouldn't apply. But it doesn't necessarily follow that the section as a whole should be narrowly interpreted, should be given its natural meaning without a predisposition to interpret it either narrowly or broadly. So in short, the narrow interpretation given to section 32(1)b, which, going back to Infineon skeleton, Lord Justice Rose was referring to in the Johnson case, means only this, that one's concerned with the date when the claimant discovers the essential facts needed to complete the course of action, not discovery of anything beyond it. But what that does not tell us is the level of knowledge required to amount to discovery within the meaning of the section. The point is merely concerned with identifying what are the facts that must be discovered. And in our case, there's no dispute about what those facts are. As respects the other suggestion by Infineon, that the court should lean in favour of the public interest in finality when interpreting this provision, section 32, Lord Justice Mayles dealt with that robustly in an important paragraph for our purposes of his judgment in OT Computers, the decision the following month. And to go to that, it's in Authorities tab 27, and I'm going to paragraph 60 on page 21. Mr. Jowl protested it's necessary. This is a case involving a distinction between a liquidator and the business from whom they take over, whether that it's necessary to treat a claimant in administration or liquidation as if it was still carrying on business to achieve certainty and thereby avoid injustice for defendants who might otherwise be exposed to claims by companies in administration or liquidation many years after the event. However, as I've explained, an element of uncertainty is inherent in section 32. It's moreover unnecessary to be too sympathetic to defendants who have committed fraud or who have deliberately concealed wrongdoing, section 32(1)b, and who, if they wish to ensure that the limitation period begins to run, can always make a clean breast of their wrongdoing by contacting their victims. And then freeze-framing that and applying it to our own case. It's not a solution to be scorned where there has been deliberate concealment, where suppliers have been operating a secret cartel, to say that they have the option of contacting their customers to make a clean breast of it, on the grounds that it's just the normal state of affairs for defendants in litigation to deny wrongdoing. And so they can't be faulted if that's the strategy they choose to adopt.
Is there anything in law which prevents a defendant disclosing an SO? I know the Commission don't like it. Is there anything which prohibits the disclosure by a defendant or responding to an SO of disclosing that SO?
My Lord, I believe yes. I believe that once the SO has been served, it remains part of the internal confidential procedure of the Commission, and that certainly without the permission of the Commission, one cannot disclose the contents of it to third parties.
Is there a statutory prohibition in one of the regulations governing SOs or oral hearings? I mean, maybe something just to clarify for us.
I'll seek to ascertain the source of that point, but subject to correction from anyone, I'm pretty sure that once an SO has been served on you, you're not entitled to disclose its terms more broadly. There's a separate rule that where one is the leniency applicant in a case of this kind, which your Lordship will be aware of, that you're not allowed to tell outsiders about those facts of your involvement until at least the time of the SO, which is a slightly different point. But I do believe, and we will check it, that disclosing the contents of the SO is not something that one's permitted to do.
And a consequential question, if you're prohibited from disclosing the SO, can you, without disclosing the SO, make a clean breast of it?
Yes.
Lord Justice Mayles.
Yes, you can. You can certainly do that. There's no prohibition on doing that whatsoever. And that would deal with the point And I say it's convenient at this juncture to point out the pertinence of it to the present case, because I foreshadowed this earlier. Gemalto's main supplier was Infineon, and they did the exact opposite of contacting the victim to make a clean breast of it. When the news broke about the Commission's dawn raids, Infineon proactively goes out to announce to its victims that an intensive internal investigation has revealed no wrongdoing. And my lord, again, to get a common sense view of these things, the members of the court will be aware that in this sort of case, very often these cartels are conducted by middle management, and if information is revealed or a suggestion that there has been unlawful collusion between the members of your company and counterparts in another, the top brass can carry out an internal investigation, which appears to be what Infineon is saying they did here. And in such a case, as a matter of common sense, there is a realistic possibility that you would say to your long-standing major customer, we've looked into this, and if there has been a problem, that you would say so. It is not something that is entirely unrealistic at all. So that in a very real sense, what Infineon did here amounts to perpetuating the deliberate concealment of the price fixing, which the defendant had engaged in. And bearing in mind the point I made earlier, that part of the purpose of Section 32 is concerned with the unconscionability of the defendant and not, and if they're not sued earlier, it being their own fault. One might think that this feeds into that analysis. So viewed in that context, the reasoning of the judge below in dismissing the relevance of Infineon's statements made to its customers at the time of the SO, that there was nothing to see, is unsatisfactory. If we may at this point please turn up that part of her judgment. It's in Core Bundle tab 9. I want to go to paragraph 90, which is on the last page, page 18. You'll see
paragraph 90 of
Mrs. Justice Bacon's judgment below. So this is how she deals with the relevance of the fact that before litigation, the defendant's gone out to customers and said, we've investigated this and there's nothing. She says, as for Infineon's denials of wrongdoing, as the Supreme Court observed in FII, it's in the nature of litigation that facts and law are commonly disputed, and it's the function of the court to resolve those disputes. The fact that a defendant disputes an element of the cause of action does not therefore mean that the commencement of the limitation period is postponed until that dispute has been resolved. But Infineon was not merely denying wrongdoing in active ongoing litigation. What it was doing was actively going out to the stakeholders before any litigation is afoot to tell them effectively that the Commission's concerns are misplaced.
When you say stakeholders, it includes customers.
Yes, I do. And when one appreciates, as I say, that one part of the aim of this provision, Section 32, is to constrain the ability of defendants who behaved unconscionably to avail themselves of the limitation defence, this sort of behaviour by Infineon should have been treated as relevant to the question whether knowledge of the cartel activities was acquired by the victim at the time of the statement of objections.
I mean, in a sense, both Mrs. Justice Bacon and Rogerson Males are correct. It is commonly, these things are commonly disputed.
They are.
But, in principle, a defendant could come make a clean breast of it. It may sound in this way that what may be a very fragile basis for a fragile and thin Rubicon that we're crossing here from knowledge into discovery could have been made very, very clear and certain had the defendant revealed the contents of the SO but chose not to. So the defendant didn't, without revealing the SO, said, well, it is alleged that we entered into agreements covering the following periods, involving the following companies, and it was price fixing, market sharing, or exchange of information. And we are meeting a statement of defence, a statement of objections. They could have admitted it, but they didn't.
That's it, yes.
So, I mean, claimants in a fragile position. They've got, you're coming up to the point at which you cross the Rubicon, to which time runs, and the defendant has a great deal of knowledge about the regulator's position in relation to their conduct, but chooses not to disclose it. The question is, whether that impacts upon the point at which the Rubicon is crossed.
Yes, and my submission is that it does, bearing in mind the dual purpose referred to in the authorities of Section 32. It's an unconscionability issue, and to pick up on that element of the reasoning of Lady Justice Rose in Canada Square and Lord Justice Males, a defendant who wishes to ensure that the limitation period starts running has this option available to them. It's unnecessary to be too sympathetic to them in circumstances where they don't do that. And in this case, indeed, when one is considering what was the reasonable state of mind or discovery by the victim, you actually have the supplier going out and saying, we've looked into it ourselves, it's misguided, this investigation, there's nothing in it. And so I move to the question of the level of knowledge which is required to trigger that word discovery in the Act in the case of deliberately concealed wrongdoing. And there are two key cases that I do need to show the court at this point. And the first is Mr. Justice Foxton's decision in Granville. That was February 2020. The second is the Supreme Court's judgment in FII, which we've now dipped into once, which was delivered 9 months later in November 2020. We can please open Granville first. That's Authorities, tab 21. I'm going first to paragraph 24, which you should have on page 7.
Did FII mention Granville?
No, didn't. And that's part of the reason why I'm focusing on this sequence, is because it's instructive to see how the principles developed. So the first occasion when this point is grappled with seriously here is Mr. Justice Foxton in Granville, and you'll see at the bottom of page 6, just go back one page and just at the very bottom, his heading for this section is what constitutes discovery, the point that we have been debating. Now if we go back to paragraph 24, here the judge identifies the distinct level of knowledge issue. In addition to the issue of what must be concealed, viz. A fact essential to pleading the cause of action, a question arises as to what level of knowledge a claimant must have, or could have had, of a particular matter for it to be said that they reached level of discovery. And then he examines this in the following paragraphs. So, taking it very briskly, in paragraph 25, the judge makes the uncontentious point that knowledge can't mean knowledge established by the judicial process or certainty. We've discussed that. In paragraphs 26 and 27 on the same page, Mr. Justice Foxton examines a group of cases concerned with discovery of fraud or deliberate concealment for the purpose of Section 32. And you'll see 6 lines down in paragraph 27, he's talking there about Mr. Justice Simon, as he then was judgment at first instance in the Arcadia case, about being in possession of facts which are sufficient to enable a cause of action to be pleaded. When are you in possession of those facts? Here, the fact that there was collusion, take that simplicity. And then towards the end of that same paragraph 27, you'll see Mr. Justice Foxton also citing Sir Terence Etherton on appeal in the same case. And you'll see from the indented quotation that the Chancellor said simply, first three lines, what is sufficient knowledge to constitute discovery within section 32.1 depends on the particular facts. So he didn't have any metric or principle to decide, he said it depends on the facts. And finally, at paragraph 28, at the bottom of the page, Mr. Justice Foxton summarises those cases by holding that these authorities establish that the claimant can be said to have discovered a fact when the claimant is aware of sufficient material to be able properly to plead that fact. That's how he's reasoning it. And if we turn over the page, go to page 8, what he then does in paragraph 29 is to split the elements of being able properly to plead a claim into three components. One, you have to satisfy your professional obligations. Two, you have to ensure the pleaded case won't be liable to be struck out. And three, you have to ensure that a statement of truth can properly be applied. And as I foreshadowed at the outset, if you focus exclusively on the second of those three components, that's whether a claimant can plead out a claim that will survive a strikeout, then you're in effect looking to see only whether a claim as formulated falls to be dismissed as standing no real prospect of success and as unrealistic. And that is why, because that's a very low bar, Infineon's skeleton for this appeal was particularly helpful in reminding us of the separate line of authorities on the conditions for being able to sign a statement of truth on a pleading. The rule is that you mustn't sign a statement of truth if you consciously have no idea whether the allegations in the pleading are correct or not. Here again I'm sticking with the example of whether there was the collusion between businessmen in the different companies. And you get that proposition from Mr. Justice Aikenhead's judgment in Berry Piling Systems. We look at that very briefly. It's Authorities tab 14, paragraph 28 on page 8. Sorry, that's Authorities tab 14, page 8. Right at the bottom, it's sidelined. On the right-hand side. It can be a contempt of court for a witness to make a statement of truth, supported by a statement of truth recklessly. That's saying something which can be proved beyond reasonable doubt that he or she consciously has no idea whether it is right or wrong. And so one may take from this that if a hypothetical reasonable claimant who's got access to the material said to be relevant would be left in the position that they say to themselves, I have consciously no idea whether the allegation is correct or not, that wouldn't be sufficient as a level of knowledge to amount to discovery of the concealed wrongdoing.
So does this mean that the introduction of statements of truth by the CPR changed the meaning of the Limitation Act?
Change the meaning of the Limitation Act?
Well, sounds like it does.
Well, it involves an obligation on a pleader, and it explains what is required for reasonable belief. Mm-hmm. It's another approach to the question of what reasonable belief means. I'm approaching it in various ways. One which I'll come to is that the Supreme Court in FII says you don't need certainty. We'll look at it's a very short passage, but they say you need to have reasonable belief that it happened. And I'm now tracking through the prior reasoning of Mr. Justice Foxton 9 months earlier in Granville, February 2020, where he splits this out to try to work out what is meant by discovery. He identifies these three components, one of which is looking at the perspective of the party, the claimant, that they should have a belief. And I'm exploring the consequences of that. But it's a form of triangulation or convergence, because the two lead to the same point, which is that you end up needing to have for Section 32 some substance, some degree of substance, which enables you to say that the underlying allegation, which is essential to the cause of action, exists.
It's a little bit circular. If the law is, as Mrs. Justice Bacon says it is, so a minimal number of facts triggers time, then I can't see why you can't sign a statement of truth saying, well, I know there was an SO, I infer from this because the law says I can, but there is there's sufficient to start the claim. You're only stating the truth of the facts that you are setting out. You're not stating that you actually know for certain that there was or was not a cartel.
My Lord, I would accept that. The way to break that circularity is to say that one needs to start with put the law to one side and start with the facts and ask oneself, because we are concerned, after all, not with something that should be arcane, and this case will decide something that is of quite some significance to people pleading in this field, whether the reasonable people in the business community can be said to have discovered something at this point in time. So leave aside the law completely, and I put forward the test. Can a reasonable person in the business community at this point in time say to themselves, in the circumstances of this case, more than, I have no idea whether this allegation of the commissions is right or wrong in the circumstances, can I say to myself, I believe, I have a reasonable ground for belief that it is correct, which tips the balance.
I mean, you as you don't know, because all you know is that the Commission have started proceedings, and that there may be an offence of some description as set out in the press release. So that's as much as you know. I mean, it probably boils down to the facts really aren't disputed. It's the question of the legal inference one attaches to these relatively limited facts. The question for us is that sufficient?
Yes.
Or isn't it?
No, my Lord, I wholeheartedly agree. A key question in this case is the one that I've just been looking at in Mr. Justice Foxton's judgment, where he analyses what amounts to discovery. The very question that the Master of the Rolls put to me at the outset of this case. That's what we're primarily concerned with on this first ground.
He's assuming, and you're assuming, that the question turns on whether you can properly plead a statement of claim. But FII doesn't assume that. And it's one thing to say you have to have a reasonable belief in the underlying allegations, that they're true. There has to be some substance in the truth of the allegations, otherwise you can't put your name to a statement of claim. I buy all that, Mr. Turner, because I think people who sign statements of claim without having any idea whether the allegations are true or false probably oughtn't to. But I see a disconnect, I'm afraid, between that question and the terms of Section 32, which actually ask you to find out whether you have discovered the matter that was concealed, the concealment. And if the matter that was concealed is simply the cartel, and the level to which you need to know about it is simply that there may be a cartel, then the question of whether you complete a statement of claim is not relevant, in exactly the same way as it's not relevant to the question of whether you have a claim for negligence, time for which has started to run, that you complete a statement of claim. When you are run over, you have no idea who you were run over by. You may be unconscious. You have no idea who ran you over. You certainly couldn't plead a statement of claim. You couldn't even identify the defendant, and yet time runs. And that was the point they were making in FII, that we've all been going on a bit of a hare.
Yes. My Lord, there is there is force in what you say, and this
You've got 6 years, just to make the point that Lord Reed made, you've got 6 years to find out who ran you over and whether you've got a claim and whether you can plead it and whether the barrister can properly sign up to the allegation that it was the defendant and not somebody else. You've got 6 years for that, and the 6 years starts to run when you know there's a problem. And that, surely you know there's a problem when the august European Commission goes to the trouble of sending a statement of objection.
well, my lord, I say no to that. Let me just respond to what your lordship's just said in a couple of points. The first is, the task, as your lordship rightly says, is when do you discover that there has been the collusion? It's the claimant. What's that point? And in the words which your lordship adverted to of Lord Simon Brown that was referred to and improved in FII, it's the point when you, what one approach is when you consider that you reasonably consider there's a worthwhile claim. And so one might apply that and say, well, in the case of the Commission having issued an SO and saying there's a case to answer, am I at the point of saying to myself, I now have a worthwhile claim? It's a good test. And we say no at that point. You know that the Commission says that there's a case to answer. It is not the same as saying there's a worthwhile claim, particularly in circumstances where Infineon has behaved in the way it has. But this is to look at things, and I was just about to come to it, through the eyeglasses of the FII decision, which your lordship rightly comes back to, because it is the Supreme Court in this area of the law. But
Which we have to take
which you do have to take seriously. However, Mr. Justice Foxton, well, I'm looking at the sequence because up until this point, you have the decisions, first of all, of Mr. Justice Foxton in February that year in Granville, and I'm showing you how he analysed it. He didn't even use the term reasonable belief or any of, or worthwhile claim, or any of the points that were referred to by the Supreme Court because it hadn't happened yet. So he's referring to the statement of claim test. But what he does do in the passage I have just taken you to, it's very helpful, is two things. He says, what does the statement of claim test actually mean? And he focuses on not what is the level of knowledge, but before that, what are the facts that you have to discover? Before paragraph 28 in his judgment. And he refers to the statement of claim test in that first connection as isolating that what one's concerned with is the essential facts needed for the cause of action. Next question is what constitutes discovery in the paragraphs that I've just taken you to, again which precede FII, and where you have the then Chancellor, as Terence Etherton, saying what is sufficient depends on the facts and so forth. And he, Mr. Justice Foxton, says it has to be enough to be able properly to plead a statement of claim and divides it into these three components. So with that observation of how the map looks, if we then go to FII, FII, as your lordship knows, was concerned specifically with the context of mistakes of law and the operation of section 32. But your lordship is right that the judges express themselves in much more general terms in their reasoning. And the key paragraph, if we can turn it up, is in Authorities tab 25, paragraph 196.
You see, I mean, before you tell me the key paragraph is 196, which is an important paragraph,
Yes.
their lordships gave 9 reasons for their decision. I would say 7 of them are directly applicable here. But we can look at 196. 209 is good because it summarises some of those reasons. But it is necessary to read them all and ask yourself the question, is that applicable to a case of concealment? Because they quite reasonably said concealment may be different, fraud may be different, we're deciding mistake. But actually when you ask that question, as I've done, as you go through the 9 reasons, most of them are actually directly applicable. And indeed, in some cases, they fall into the trap of making statements that are themselves conclusive almost in this case.
Yes.
I mean, which you say, well, it's overturned.
Well, I'm not doing that, Michael. What I'm seeking to do, if we have 196
Yeah, I've got it.
on the page.
But
I'm
you
seeking-
like
I'm-
196
essentially,
because-
I'm seeking to be very brief and to
Yeah.
cut to the conclusion in the reasoning of the judges in FII, which is in this paragraph.
Well, it's not actually, if I may respectfully say so. Unfortunately, what they do is they start by saying what they think, why they think DSG was wrong. And they start by saying why they think Lord Brown was right. And then they give a series of reasons which support that reasoning. And it's true they come upon Halford and Horwood as being supportive of Lord Brown's reasoning, but it's not the essential. This is just right bang slap in the middle of their essential reasoning. I mean, I'm not stopping you, but I just don't want you to think that I'm going to accept that one passage which talks about reasonable belief overtakes all the others.
My lord, I accept that. That might be something that I'll need to consider over the shorter journey. This paragraph, nonetheless, and I'll take you to the follow-up paragraph in the summary of their conclusions to bear this out, because those are listed in turn, paragraph 213. But you see from paragraph 196, casting your eye over it, that here, when considering what all of the previous authorities, where all the previous authorities go, the court says that within, for the purpose of section 32, one is looking at beliefs, not with the truth established by judicial decisions, and in the final line, that reasonable belief will normally suffice to amount to discovery. If you go forward to the conclusions, we perhaps then ought to just pick that up too, on page 96 in the same judgment, with the list of conclusions, seriatim in paragraph 213. You look towards the bottom of the page between letters F and G. By tying the concept of discovery to the ascertainment of truth, the decision in Deutsche Morgan Grenfell contradicts the principle that limitation periods apply to claims regardless of whether they're ill or well founded. The claimant can't be required to have ascertained the truth for a limitation period to apply, consistently with authorities concerned with analogous provisions of the 1980 Act, which was sections 11 and 14, a reasonable belief will normally suffice. And that is, I take your lordship's point, that's the proposition that I'm extracting for my purposes.
But it's not the ratio of this case. The ratio of this case is that what underpins section 32 is something different about the meaning of the word discovery, and something different from what we previously thought, because we had DSG, which said that discovery, as far as a mistake is concerned, could only take place at the end of a very long process of litigation. And they said no, discovery comes at a much earlier stage. The reasonable belief bit is you have to be careful not to be confused by interpreting discovery by applying the objectivity that is contained in reasonable belief. The difficulty is, of course, you're right, ultimately, we do have to decide, as my lord put it a little bit earlier, whether whether there was sufficient knowledge of the concealment, that there had been concealment, the cartel that had been concealed. But saying reasonable belief re-imports the whole of the statement of claim test. And that's not what they're doing. They're deliberately saying that's not right, even for fraud. So they're saying we're not deciding this, but the statement of claim test is negated by their reasoning for fraud, and therefore, by example, by analogy, really, for concealment. I mean, I think logically.
Yes. So my submission based on this, I take those points and I would reflect on that further.
Just while reflecting, I mean, the 195 I think seems to us to be important, because that, in a sense, if it's not the statement of claim test, it is that test which is formulated and approved of in 195, and it's how that test then applies to their minimum facts.
My Lord, yes. So I put together 195 and 196 and the corresponding summary of conclusions in 213. In 195, at letter D, you see the reference there to the standard that a worthwhile claim arises, which was picking up on Lord Brown in Deutsche Morgan Grenfell.
If one starts more systematically, I'm sure everybody can read this differently and distill it slightly differently, but you've got to know the essential facts on which the cause of action is based. You have to know that with sufficient confidence to justify embarking on the preliminaries, and then they give examples such as issuing a writ, taking advice, collecting evidence, and then they approve of the dissenting judgment of Lord Brown, which is, in similar terms, time doesn't run until the claimant knows actually or constructively that, and then ignoring the mistake element of this, knows actively or constructively the essential ingredients of the cause of action to the standard that a worthwhile claim arises. So yes, we've got to grapple with what's meant by worthwhile and what's meant by sufficient confidence. They're not terribly precise concepts, but it's really taking those and applying them to should be incontrovertible facts. Where do we end up? Which side of the line are we on?
That's it, my lord. I agree with that.
Do you agree with that?
Well,
because if that is right, then the question is not whether you can plead a claim or whether you have reasonable belief in the claim. The question is whether you know sufficient facts, no essential facts, in other words, that there was a cartel, not absolutely, or that anybody thinks so absolutely, but with sufficient confidence to justify investigation. And I don't think you do accept that.
Yes, so I stub my tongue on that. To justify investigation, I'll come back to that, because to justify investigation, we understand to mean, going back to the example I began with in paragraph 192 on the previous page, to mean that is something that happens. You're investigating matters for the purpose of putting the pleading together after the elements that we've just been canvassing with yourself and Lord Justice Green in paragraphs 195 and 196. And so to take it in stages, our submission is this. Looking at paragraphs 195 and 196, first question, as Lord Justice Green says, is what is one concerned to discover? And that is the essential elements of the cause of action, without which the cause of action is incomplete. Second question is what level of knowledge, using Mr. Justice Foxton's framework, does one need to acquire? And at letter C, in paragraph 195, there's the reference to sufficient confidence. Pausing there, as Lord Justice Green says, sufficient confidence itself is, as it were, begging the question, when has one acquired sufficient confidence? And then at letter D, you have the reference to it being to the standard that a worthwhile claim arises. And finally, in letter, at the end of 196, just above letter G, a reasonable belief, not in everything that you need to include in the pleading, but in the essential ingredients. So here, let us take the collusion. So putting all that together, what one must have, according to the Supreme Court, in my submission, is sufficient confidence to mean that a worthwhile claim arises. You then go off and do the embarking on preliminaries referred to previous paragraphs 192, which takes time to put the claim together. But the worthwhile claim, in our case, arises when one has a when one does have a reasonable belief that there was the collusion, that it did occur. And our essential point.
So let me just take that very slowly.
Yes.
The worthwhile claim arises only when you have a reasonable belief that the claim
That the collusion
that collusion has occurred.
has occurred, yes. I'm using that as shorthand.
Now, where do you get that from out of FIN?
So reasonable belief is at the end of 196 what suffices.
No, but that is simply saying it's reflected.
Yes.
Well, on those cases, the test there applies in 195.
Well, then, if one takes the standard of the worthwhile, whether one can say to oneself reasonably there is a worthwhile claim, apply that to the circumstances of this case, and I'm about to turn to the facts. Mm-hmm. You ask yourself, in circumstances where the competition authority has said, we've issued a statement of objections, there's a case to answer, at that point, someone in the position of the claimant here, Gemalto, can say to itself, a worthwhile claim now arises, such that we should put in hand the preliminaries to creating a statement of claim.
Can I just say something? I mean, if you say, if your submission is the worthwhile claim arises only when you have a reasonable belief that collusion has occurred, right, that introduces a subjective element, which is definitely not right.
When a reasonable
When
a reasonable
an
person,
objective person, a reasonable
Yes.
person could have a reasonable belief.
yes, and in circumstances where a reasonable person, faced with all of the inputs that were received in this case, and we'll turn to the facts in a moment, but one of them will be that the main supplier is saying.
So can I just start by asking you again the question that really worries me about this case is how can it be that a reasonable person could not have a reasonable belief that a collusion has occurred when the European Commission issues a statement of objections?
Because when the Commission issues a statement of objections, it is saying that there is a matter here that means that there is a case to answer. Commission is not the industry, it's the competition authority. The Commission's investigations sometimes run into the sand and come to nothing. The Commission's allegations are not uncommonly withdrawn. Here, and I will turn to the facts so you see the essential fact, it is not the posture of a reasonable person in the position of Gemalto that they would say.
You accepted, Mr. Turner, that the question was when a reasonable person could have a reasonable belief.
Yes.
Now, if it's a reasonable person could have a reasonable belief, and we know that statements of objections very often result in decisions, don't they? They sometimes
No, of course they do, Mark. Yes.
Of course they do. So to say that once you're faced with a statement of objections, a reasonable belief a reasonable person could not have a reasonable belief that collusion had occurred at that point is a very big statement indeed.
Well, my lord, with respect, I would submit that that is approaching things in the wrong way because...
Wrong end of the telescope.
Wrong end of the well, it's the right end of the telescope. But the reason why that's not right is that when one knows that a statement of objections has been served, what one knows is, and your lordship's quite right, there must now be a chance that this investigation is going to result in an infringement decision. Of course your lordship's right about that. You know that there's that. You also know, however, that this investigation may run into the sand, or these particular allegations, or these allegations against these particular defendants may be withdrawn. So you know both of those two things may happen. And where you are an industry party which knows that either of those events may crystallise, you do not, my submission, reasonably know that a worthwhile claim already arises. Because either of those forks in the road may be
It's
taken.
really very narrow, isn't it? It's an inference here. It is what is the inference that can be drawn. It's an inference based upon the conduct of an expert regulator who itself refuses to disclose the basis of its belief, but nonetheless discloses the fact that it has started an investigation and issued an SO. And according to the press release, I think there may be a breach.
Yeah.
And as to the nature of the infringement, it says breaches such as. So it just throws out some typical horizontal examples. That's the bare minimum facts. So what can you infer from that?
Yes.
That there might be an infringement of a horizontal nature. And the question is if you plead that, I mean, we know what's going to happen. It will inevitably be stayed. But does the law say, on that very bare minimum, time runs?
Exactly, my lord. I think in the light of what your lordship said, I will turn to look at some of these basic facts because they will illuminate this point. But my key answer to what my lord the Master of the Rolls has just said is that when you know that a statement of objections has been served on the suppliers, you do know that there is a possibility it's going to result in an infringement decision. You also know that there is a possibility it will result in nothing. And so to pick up the phrase that we've seen in paragraph 195 of FII, that point, my submission is you do not say to yourself, a worthwhile claim now arises, and I'm going to invest in the what they call the embarking on preliminaries, of looking into putting a statement
Nobody
of claim
forces
together.
you to bring a claim, Mr. Turner. This is a commercial world. The fact that limitation starts to run doesn't force you to investigate a claim or to do anything. All it says is, if you don't, you've only got 6 years in which to change your mind. And it's also a fact, isn't it, that decisions normally follow statements of objection within 6 years, well within 6 years.
Yes. Come back to one of the purposes, which I've taken you to from Canada Square, of this provision. It's to, and there's another statement of it in FII itself, it's to ensure that a plaintiff, a claimant, is not unfairly disadvantaged by not being sufficiently aware of the essential ingredients of the cause of action. It's essentially a fairness point. And the reasoning of their lordships in FII says that the starting point should be when you appreciate, based on information that you receive, that a worthwhile claim has arisen. And so the point is this, when you know, and I do now need to look at what happened so you can see it, when you know that a statement of claim has been served and you see the terms, Lord Justice Green referred to of the press release that the Commission puts out about what it signifies, you say to yourself, a worthwhile claim now arises, whatever you then make of it, such that it is appropriate for this court to decide that there's sufficient to amount to discovery within the meaning of this provision. So, my lord, with that, if I may, I'll turn to the facts. I've got some way to get through, so I'll be as brief as I can. There are 3 periods to look at here. There's 2009, which is the news of the Commission's dawn raids. Then there's 2012, when you have information requests sent to Gemalto. And then you have 2013, when you have the press release announcing the statement of objections. So I will go through this quickly. In the supplementary bundle, if we can please turn up SBB at tab 1, page 1. here you have, magnify that please. This is the terms of the press release actually announcing the inspections.
Not in my bundle.
SBB tab 1.
I've got to say, Mr. Chairman, I wasn't aware I had a bundle called SBB. I've got an SBA.
I see. So it seems to be correctly noted on the Opus system because it should be on the screen in front of you.
Extract of day 1 at preliminary issue trial.
If you have supplementary appeal bundle, has SBB after tab 4. So you've got 2 bundles in one.
So yes, I'm sorry.
SBB.
It's called SBB. As my Lord Justice Green says, it's within
Page 47.
supplementary bundle. Yes. That's then divided into various sub-tabs. SB,
I've
A,
got it.
B,
It's
C, and D.
Page 47 in the electronic. Thank you.
Apologies, my Lord, I don't have that precise system.
Well, for future reference, it's the only system I ever use.
My Lord, that's noted.
The problem actually is that the electronic bookmarks that are automatically generated don't have the references on them that you're using.
I see.
If someone had done it properly, they would have.
Yes, my
Not
Lord.
you, Mr. Turner, no doubt. But
Well, my Lord, those behind us will take that on board. This is the announcement of the inspections, and you'll see from the second non-emboldened paragraph that the Commission is very clear that it tells the public what surprise inspections actually mean. It's only a preliminary step, doesn't mean guilt, it doesn't prejudge the outcome, and the Commission respects the rights of defence. So all of that is concentrated in that paragraph, and that's what's therefore said to the public when the investigation kicks off. In fact, the investigations, the Dawn raids, had occurred in October 2008, and this press release about them is given in January 2009. That and the associated chatter in press releases led to internal discussions within the company, and I'll show you a very small amount of those, but there are 5 key points. First, there's total surprise. Second, entirely reasonably, you have the clear and repeated recognition that this is only an investigation and nothing has been established. Third, at this point, they find that the investigation covers entities which subsequently fall out of the ongoing investigation. Fourth, that Gemalto sets in motion getting advice from law firms who are experienced in the field, not because it considers there already is, to use the language of the Supreme Court, a worthwhile claim, but it's a contingency. The language they use, you'll see, is in case the investigation turns sour, converts into a decision. And fifth, what the company does, and to pick up on my Lord the Master of the Rolls question earlier, is it tries to fish for serious information. It does want to know what it can about this, but that comes to nothing. And very quickly, you can see these points. And I apologise if my referencing is not going to be easy for the court. I have this on the Opus system as SB in supplementary bundle D at tab 2, first page.
page 134.
So here, if you have that, it's on screen now. You have at the bottom an internal email from the senior executive of Olivier Pugh, and he's responding to the press releases which have come out, and he says in the third line in parentheses, we found this out, it doesn't mean that they're guilty. Perfectly reasonable appreciation. And then if we go in the same tab, SBD, to tab 6, page 4, you have some speculation from one of the officials who was a witness in the case, called François Dupré.
Sorry, you're just going to give me that reference again.
I'm sorry, yes.
SBD 64.
6. You can go straight to page 3 for speed.
Yeah.
Companies speculating about what on earth has been going on. We have an English translation, but unless the court wants, I take it that you can read this for yourselves, and you'll see at the very foot of that page that this individual is trying to work out who has benefited from having made this complaint. And you see the last line, le crime qui reste à démontrer profite donc à quelqu'un d'autre. He was there considering whether one company, Samsung, was perhaps the source of it. And he says the crime which remains to be demonstrated is profiting someone else.
Sorry, I don't have a problem with the French. I just can't find what you're talking about on the page you've given us.
150.
I'm sorry, if you go to the page 3.
Oh, page 3.
Yes, sorry. Right at the bottom there.
Thank you.
You see the last line.
Yep.
Mm-hmm.
Then if you go to, still in SBD, to tab 8, page 1. This is the point that they consider getting in firms with heavyweight experience in dealing with EC investigations, and you'll see in the middle of the page that email from someone called Mark Bergman, 4 lines down. This was something quoted by the judge in her judgment. If the investigation turns sour and we consider suing our suppliers, we want to have a heavyweight on our side. That's the point I made about viewing this as a contingency. And finally, in SBD, go back to tab 6, page 5. You have one of the officials about halfway down the page, Edouard, referring to one of our witnesses, please use your and the key account buyer network and fish for serious information on this. So again, chiming with my Lord the Master of the Rolls comment earlier, you do have a case of a company that does want to try to work out what's going on. Fish for serious information on this. And as against this, you then have the behaviour on the defendant side. We go to SBE at tab 2, page 1. This is the slide that I've been referring to before. It's an Infineon slide, additional information on investigation of EU Commission for selective customers and partners. I'd used the term stakeholders before. And you see from the 4th bullet, the investigation refers to a longer period in the past, centering around several years back. And then intensive Infineon internal investigations have not revealed any suspicious facts. That was the general message that they then broadcast to selective customers and partners. That includes our client, Gemalto, and it's complemented by the evidence that was in the case before the judge below on the contents of the direct messages given by Infineon to Gemalto. And here, if you go to SBA in the supplementary bundle at tab 3, page 1, this is the witness statement of the man who was asked to fish for serious information. His name was Edouard Roqueplot. If you go in it to paragraph 16 on page 5. At the top, he talks about his main interactions with Infineon, and he specifies who his main contact person was there, someone called Bernd Meyer, who was the sales director. Now if you go over the page to page 6 and look at paragraph 21, the evidence was that he actually asks Bernd Meyer about the investigation over the phone or possibly at one of the meetings. And he records, he told me that the commission, 4 lines down, investigation was not an issue for them. It was just one in the long list of investigations carried out by the commission. In other words, he suggested Infineon had nothing to hide from the commission and it was business as usual for them. And the reason I draw this to your attention, my lords, show you that the sales director is pouring cold water on the matter, is because it does go to the question that rightly the Master of the Rolls did raise at the outset, which is, well, what does one conclude reasonably when one finds out that there has been an investigation started and then an SO? And these are relevant pieces of information that reasonably, not subjectively, an entity in the position of Gemalto should take into account.
Can I just make sure I've got the chronology right? Because you said then an SO. I thought this was before the SO.
I'm sorry, yes, this is absolutely, you're quite right, my lord. Take this in sequence. So this is 2009.
Yeah, that's what I thought it was.
You're quite right. So then the second stage is 2012. I said there were 3. Second is 2012. This is the information requests. They're served in July and September 2012. And both ask about 2003 to 2006 for purchasing information in neutral terms. So in the supplemental bundle, if you go please to SBC, first page, SBC tab 1. Here you have the first of these requests for information. It's 3rd of July 2012. Go to page 3, paragraph 1. You need to see, Lord Justice Green referred to this earlier, but you need to see the terms in which they describe what they're doing to the recipient of the document. So page 3, first paragraph, last few lines. The present request for information is addressed to you as a customer on the relevant market, which may have knowledge of facts thought to be useful in the investigation. If you turn over the page to page 4, look at paragraph 3. The information you're requested to provide in reply to this request, information, this is at the top, will enable the Commission to assess the compatibility of the alleged behaviour with the EU rules on competition in full knowledge of the facts and in their correct economic context. That's how they describe what it means to have this document, which you will see the judge used as the basis for the inference that there was a cartel in this period. Then go to page 6 in the same document. You have the questionnaire. And halfway down the page, the heading 2, questions relating to the functioning of the business in the period 2003 to 2006. Please reply to the following questions with regard to the period 2003-06, the relevant period, during which you were active in the production of smart cards for which you were purchasing smart card chips from different suppliers. And if you go over the page, page 7, you look, for example, at paragraph 8 near the top of the page, page 7. You see the sort of market data gathering which is involved. It's all designed to allow the Commission fully to understand the market. It does not connote that at this stage any view, even a preliminary view, has formed. You then have in SBC 4, in the supplementary bundle, SBC tab 4, if you go to page 1, you have the RFI, the follows several months later in September that year, 25th of September. There were two of them. If you go to page 4, it's got a similar boilerplate about what it actually means to a recipient. If you go to page 4, you see the questionnaire. Please state the types of smart card chips listed in the table below various things. Here, now, in the rows across, you have 4 suppliers mentioned: Philips, Samsung, Renesas and Infineon. And if you turn over the page, you see that this is also in relation to 2006, again, 2003 to 2006. And my essential point is that nothing in either of these two documents you've seen in 2012 gives rise to the inference that this is the period which the Commission will later form a preliminary view is the cartel period. This is a period that the Commission is gathering information about in 2012, and that is not the same thing. So that's all you have in 2012. You then go, my Lord Justice Birss rightly picked me up on, you then turn to 2013 and the Statement of Objections, which is issued and announced in April. So here we go to SBB, tab 2, page 1. We magnify that. And like Lord Justice Green, I would like to focus on the wording which is used to the recipients of the press release. The European Commission has informed a number of suppliers of smart card chips of its preliminary view that they may have participated in a cartel in breach of EU antitrust rules. And the third paragraph, the Commission has concerns that certain chip suppliers may have agreed or coordinated their behaviour in the EEA in order to keep prices up. The rest you can read for yourself, but what I wanted to draw your attention to was the explicitly tentative terms in which the Commission explains to the public what it means to have taken this step. You then get a meeting of the Gemalto board 2 days later, the 24th of April, a very short piece, SBD tab 12, page 1.
I'm sorry, I'm slightly behind. Just give me that reference again.
I'm sorry.
No,
SBD tab 12,
SBD,
page
yeah.
1.
Thank you.
So this is a meeting of the board. Press release has just landed in the terms you've seen. And if you go to page 2,
Sorry, SBD 12.
SBD 12,
Oh, yes.
page 1. If you go to page 2, this is the board minutes. And one of the things they consider is, what does this mean? And you see from the unredacted bit that should be on the screen in front of you that they've received media queries. And they say, we ourselves are not a manufacturer of these chips, so we weren't involved in the investigation. We could only be victims of unlawful activities, if any. Now, if any reveals the position of Gemalto at this point, in that it does not appreciate that, to use the Supreme Court's phrase, a worthwhile claim arises. And my submission is that this is a reasonable position for the business to adopt at this point. This is not something that should be dismissed as subjective and which should be left out of account. Given the information...
There are a million reasons why there might have been a close relationship between Gemalto and the members of the cartel. I mean, it's true what you say. Of course, it's one factor to be taken into account. But the objective person will not be looking at what subjectively the relations may or may not have been between Gemalto and Infineon at that stage. The objective person will be looking at the objective facts, and the Statement of Objections, which has been now 4 years of investigation by the Commission, might be taken to be to a competition lawyer, who they can be taken to have consulted, quite a clear indication that there's something to go on. They don't know the details of.
My lord, agree with that. I certainly wouldn't say that the subjective relationship between Gemalto and its suppliers is something that you need to take into account.
Don't take it into
However,
account, but it could be.
However, what one should do, and again this picks up on something from the FII judgment, is you, when considering the attributes of the reasonable claimant, it's appropriate to consider a claimant, a hypothetical reasonable claimant, in the same position as this one, of the actual claimant, and with access to the same information. So what I'm seeking to do is show the court the sorts of inputs, of inflows of information that are received, and not to say that the reaction of this company subjectively is decisive or should affect your view of discovery. But what I do say is that it is indicative of how a reasonable business, because this is a reasonable business, would respond to the press release in the terms that the Commission has sent out, in view of the history which I have shown you. Perfectly reasonably, in short, when you look at this company consciously has no idea whether the allegations are well-founded or not, to use one phrase. They do not consider that a worthwhile claim has arisen, and nor, if they consult competition lawyers at this point, would they add some further clarification. Yes, in fact, you do have a worthwhile claim, because there is nothing more than what I have just outlined.
The point will be taken against you. I don't find this easy, but the point will be taken against you is that this simply triggers time. You preserve your position. Your lawyers will advise you once they see the decision whether or not to issue proceedings, and provided the decision is within 6 years, which generally it is, you're protected.
Well, my lord, I'm going to come to that, because that raises one of the other points that I do need to cover about the judicial policy objective and avoiding claims being filed, as it were, speculative, to put your towel on the deck chair, to mark your...
I think 195 introduces a degree of, if you like, justiciability or pragmatism into it, in the concept of reasonable confidence and worthwhile, when we all know that if proceedings had been started at this time on the SO, they would instantly have been stayed. You wouldn't have got to disclosure, you wouldn't have got to anything. They'd have been disclosed pending the decision, and the defendants would say, ludicrous, let's wait and see if it's a follow-on. So, right. There is a, to what extent that leads to a policy overlay, I think is under matter. But the concept of worthwhile and reasonable confidence in 195, and confidence to justify preliminaries when you know there virtually won't be any preliminaries, I mean, that might be a consideration.
Yes.
And when you read the Reuters report of the SO at page 182, which accurately reflects SBE 6.1.
My lord, I'm sorry, I don't have the same...
no, I've just given you your reference. SBE, tab 6, page 1.
Grateful.
It's to say, when you read this, Infineon could face fines after European competition regulators says they may have colluded to fix prices for chips used in mobile SIMs. The European Commission said it sent documents setting out its concerns to the companies. It's suspected of behaving like a cartel in the market for smart card chips. Didn't identify the companies, but Infineon and Philips confirmed they'd received statement of objections, 90-page document, referred to allegations of wrongdoing in the years 2003 and 2004. The idea that when you read that, you haven't discovered that something might have been concealed is sort of a little bit unrealistic.
Well, my lord, if you put it in those terms, discovered that something...
That's why I'm asking you.
If you put it in those terms, discovered that something might have been concealed, then I would agree. But I would say that, yeah, I would say that's not what one's looking for. It's discovered that something has been concealed. And if you look at the the second full paragraph in that, the European Commission said it sent documents setting out its concerns to companies. That remains the position. At the end of the day, the Commission has set out its concerns. In this case, one of the inputs is that the main supplier has said there's nothing in those concerns sometime earlier to Gemalto. And therefore, you cannot say at this point, to use that phrase from the Supreme Court, that a worthwhile claim arises. And turning to my Lord Justice Green's point on this a moment ago, yes, I accept that the first point is whether there's a policy overlay, and I'll come to that in a moment. That is relevant. It should be relevant to the decision in this case. But approaching it, first of all, purely as a matter of principle and asking oneself, does a worthwhile claim arise at this point? A worthwhile claim does not arise in the sense that you think that there has been collusion. There appears to have been collusion.
I know you love worthwhile claim, but I like worth investigating, because worth investigating is slightly different in this sense.
Yes.
That it takes the subjective out of it. A worthwhile claim is something that somebody considers worthwhile, which is a subjective question. But worth investigating, is more objective. So you read this in the newspaper and you're a business person, a commercial person. You go back to your office and you say, did you see in the FT or in Reuters or whatever it might have been, that the EC's just spent 4 years investigating and sending 90 pages to all these suppliers of ours? Surely we should have a look at that. And we know that you did have a look at it. You sent it to your competition lawyers.
Yes.
So doesn't that really answer the question for you?
My Lord, no. And I'll approach it in this way. I marry the two terms that you and I have used. A worthwhile claim, worth investigating.
Okay.
My proposition is that one starts with whether there is a worthwhile claim. If there is a worthwhile claim, that is the condition that makes something worth investigating. In my submission, it is the wrong approach to say there's something here which might turn out to be an infringement, and that makes it worth investigating, so that one approaches it from the starting point of a possibility that you try to drill into, as we saw here, try to fish for serious information. They spoke to Infineon and got the response you've seen. My proposition is that the starting point is that there's a worthwhile claim, and then, if there is, it's worth investigating in the sense of embarking on preliminaries used by the Supreme Court and FII to mean doing all the things you then need to do to prepare a case for court.
When you start putting it negatively, though, it does sound a bit silly, doesn't it? I mean, if you say, well, I've read all these articles and I know that the Commission has spent 4 years doing all this, so it's obviously not worth investigating. I mean, that sort of sounds a bit ridiculous.
Well, my Lord, let me put it another way. At that point, it is worth the Commission investigating, and it does. And it does want to investigate.
I mean, we're talking we're not talking about the PC plod who has no expert knowledge. These are the most expert in competition law people in the European Union.
Yes.
That think it's worth investigating.
They think that
you follow on and you say, but no reasonable person would think it was worth investigating.
But because my submission is you have to disentangle these two things. The first question is, do you have a worthwhile claim as the claimant, the potential claimant? If you do, that makes it something worth you investigating. What your Lordship is drawing attention to is that when the SO, there's an announcement that an SO has been issued, obviously the competition authority thinks that there is a possible infringement worth investigating. And my point is that a possible infringement worth investigating is different from apprehending that a worthwhile claim exists and then investigating in the sense of embarking on the preliminaries to issuing a statement of claim as a result.
Mr. Turner, part of what I find difficult is that I have in my mind a picture of your client's law firm sitting there investigating and then also wondering about whether it's reasonable to be investigating, which is essentially what your submission amounts to.
My lord, I'm sorry, I missed that.
We know what happened, and it seems perfectly sensible, if I may say so, that your clients on reading this stuff tooled up with a law firm who started thinking about it. And yet, part of the debate we're now having, I have in my mind a conference room in whatever law firm it was, where all the lawyers investigating this claim are thinking about whether it's reasonable to be investigating the claim.
Oh no, my lord.
But that's exactly what
No.
this is.
So the company, when it finds that there's an investigation that's opened, says, as you've seen, we want to recruit some lawyers to advise us on the process.
Right.
So they need to know what the process involves, what it means, and how it ends up.
Well, that was the Dawn Raid.
That's right. They do not, however, form a view that there is a worthwhile damages claim for damages for loss caused by a cartel, at the point when all they know is that the competition authority considers that this is something that there's a case to answer.
Right.
Okay.
That's the submission.
Just in terms of worthwhile investigation, are you saying the worthwhile investigation has to be by the claimant? Because in this case, in one sense, the worthwhile investigation was subcontracted to the Commission. And if proceedings had been started, at that point to protect time, at a later stage following the decision, you would have been able to come back with the benefit of the Commission's investigation to further investigate, for example, in relation to causation and quantum if it was a follow-on. So I suppose there was an investigation, not by the claimant, but the Commission undertook an investigation.
Yes, my lord, I think one needs to disentangle two things. First is the reference from FII to apprehending there's a worthwhile claim. What that means is a worthwhile claim for damages. That's one thing. The second then is to pick up on the FII reference to embarking on preliminaries and investigating. It means from that point, investigating, when you apprehend there is a worthwhile claim for damages, what needs to be done in order to put the claim together.
I mean, if that were the test and it had to be, could you investigate in domestic law, the answer would be no, because immediately the shutter would come down on the action, everything would be stayed, you wouldn't get disclosure, there wouldn't be preliminary investigations until the Commission decision came out. That would be the position in domestic law, but at the community level, everything is then proceeding with the Commission, and then it adopts its decision, and then it goes back to the National Court and subject to appeals. The investigation then resurrects itself.
Yes.
I mean, I'm applying FII to this particular context. One can see how there might be preliminary investigations ongoing if you had started proceedings at the time of the SO.
Well, perhaps time allowing, we should come to that question of how these interact. But my submission is that for the purpose of Section 32, the debate is really I'm using this as shorthand. The debate has taken us to the point where the potential claimant should have reached a position whereby they apprehend that a worthwhile claim for damages exists. And what my submission is that means is a worthwhile claim for damages exists because there are reasonable grounds to believe that there's been a cartel. And the question is whether the fact that the Commission says there's a case to answer, it may come to nothing or it may turn into a decision, means that you've arrived at that point as a matter of principle. And my short submission is not yet. Not yet. So, my lord, in view of the time, what I shall do, if I may, is I'm going to go extremely quickly and perhaps cover the decision and look at the pleadings for a couple of minutes, And then after the short adjournment, I'll need to be very compressed. I would like to go through the judgment below, relevant parts, and make my submissions. Those submissions will include the need for me to address at least Nokia, because we haven't talked about that yet. It's the decision of Mr. Justice Sales.
But Nokia doesn't really say very much, does it? All Nokia says is you're going to give a little bit of indulgence, and the facts of Nokia were a million miles from here.
Well, my lord, so this will be in line with my submissions. It is, however, a major point in the case.
Well,
on the
let's see
other
if
side.
it is when you come to reply. But I mean,
Well,
I don't think you need to respectfully. I know we had a bit of a Barney in correspondence about your supplemental skeleton, but
Yeah.
personally, I think you were being a little, what should we say, oversensitive in putting all that in. But you want to mount your appeal and worry about what they say afterwards.
Well, you'll see it's a part of the reasoning of the judge below. That's a reason why.
Okay, well, we'll come to that when you come to
So
anyway, now we're going to look at the decision.
briefly, let's round off by looking at the decision and then the pleadings before the short adjournment. So the decision you will find, if you still have the supplemental appeal bundle, at SBB on the pagination that I'm using at tab 6. And if we go to page 5, you have the first substantive page.
Sorry, you said SBV.
SBB for Bravo.
SBB.
SBB. So there you have the first substantive page. You go to page 6, recital 1, top of the page. There you have the summary of the essential findings, collusion between the main suppliers of smart card chips, and explains what the contacts that were collusive related to. In other words, that they did speak to each other and coordinate their pricing and other aspects of market behaviour in that way. Page 8. You have the description of the market, and this is one of a number of similar tables that I can show you. You see here a full sweep of information being considered, because the Commission does set out how the market operated and looks at a wide vista. So here it covers the years 1999 to 2007. It may have gathered information from parties about some of that, in order to inform its understanding of the market generally at the earlier stage. You see that the way that that feeds through to an infringement decision is that it sets out information relating to quite a long period as part of its reasoning. And you'll see the same if you go to page 9 over the page, table 2 at the top, and many other examples of this. In other words, when the Commission gathers information at the earlier stage, it may be looking not at a period that it suspects as being the infringement period, it's gathering information generally about the market. If you then go to page 14, you have the description of the events, and here are certain objective facts that the court needs to take into account in this case too. So at recital 59, you will see they refer to several aspects of the smart card chips market which are important for the framework, and A was a constant fall in prices for these goods, the smart card chips, and B was the downward stream pressure on pricing and margins from the largest customers. That includes Gemalto. You see that there are aspects there which, although they might be consistent with you ultimately concluding that there has been a cartel, if you put on the eyeglasses of a reasonable industry person who sees falling prices, who knows about the pressure that they can exert on the suppliers, these are objective facts, then those need to be taken into account in whether at that point you believe there is a worthwhile damages claim, or whether the Commission may have got this wrong. Go over to page 15.
Well, not at this stage. You're not saying that there's no worthwhile claim when they've issued their decision.
Not at all, Mother. What I mean is that part of the
know
fact...
any of that until this time.
No, but what they didn't know that the Commission would find that. But what you can see is that as market facts, the circumstances of this case are...
Well, you're not saying you can't have a cartel when prices fall, are you?
Not at all.
No.
What I'm saying is that if prices are falling and customers are exerting pressure, there's no reason to give you additional support to thinking, well, maybe the Commission's investigation means that there is a cartel.
I think, as we all know, Mr. Turner, there's more than one way to run a cartel.
There is more, well, my lord, that's right. But what I mean is that in the absence of that, in the presence of what appear to be factors consistent with a market working properly, if someone is saying to themselves, do I now think that a worthwhile claim arises, they would not. So if we go then to page 15, recital 62, you'll see that what was going on here, because your lordship is right, that it was due to the particularly sharp fall in prices in that period that the suppliers got together and acted illegally. That's actually what led to it. So your lordship's quite right as to how this can arise. But my point is that from the point of view of the customers, it means that there's a negative there in terms of thinking, does this mean a worthwhile damages claim arises at this point? Go to page 22, show you just a few more things in this. Paragraph 96, recital 96, towards the bottom in the italicised text, 5 lines up, you'll see that this was one of those cartels where the parties are saying to each other, be careful not to leave any document or records when you contact competitors, but only make oral communications to avoid any problems with the antitrust laws. And again, if you go to page 23, you have a similar thing, paragraph 115. This is a...
This is sort of wear gloves. When you...
Yes, so this is now Renaissance, 5 lines up from the bottom, again in the italicised text. After reading it, please erase completely this email from your computer. Thanks for understanding. So you see the sort of deliberate concealment going on. Page 24, recital 273. The Commission concluding there's evidence showing the parties knew about the illegality of their contacts. Some of them took measures to conceal their collusive behaviour, and they refer to that email, the first one I showed you, which was Samsung. The second is an internal Renaissance email in the 2 recitals I've shown you. And finally, recital 395 on page 26. And this is relevant. It's recital 395 because this goes to a point I'm about to develop after the short adjournment on unconscionability. The cartel contacts were driven by the parties' knowledge of the business environment, characterised by a small number of large customers with high buyer power, etc. A downward trend of prices. They showed their willingness to influence the environment to their benefit. Some references in the file to the fact that antitrust concerns were expressed and measures of concealment were taken. Finally, on the following page, 27, you have the decision itself. And we say that that decision, that provides the damages claimant and their lawyers with the appreciation that there is now a worthwhile claim for damages. It is a pure follow-on damages case. Finally, my lord, if you'll allow me the indulgence, it may be efficient for me just to show you the pleading. So if we go in the core bundle up to tab 11, page 1. This is the claim form, originally issued on the 19th of July 2019. That is a little under 5 years after the date of the Commission's infringement decision, under 5 years from that date, but obviously more than 6 years after the press release which announced the SO in April 2013. the defendants don't initially take a limitation point in their defences. They both introduced the limitation defences together by amendment in April last year, 2021. And their amendments...
Before FII?
This is after FII.
Which was November 20.
Yes, November 2020. Absolutely. So then they introduced the limitation defences, and they're in similar form. In the interest of speed, just look at Infineon's. That's same bundle, core bundle 13, tab 13. If you go in it to page 3, you have the red amended text. And I just want to show you the way that they approach the limitation at this point. 9b, they say that the claim was issued on the 19th of July 2019, so it's after the primary limitation period. 9c, they say that they will say that there's this, the claimants had discovered any such concealment. We can put aside could with reasonable diligence have discovered it, because that's no longer an issue. So the claim is that the claimants had discovered the concealment. 9d, here we have the relevance that's attributed to the information requests. If you look at 9d, the relevance of these information requests back in 2012 is not said to be that they allow an inference of the period of cartel activities, which is what the judge goes on to find. Here you'll see their pleaded contention, and it's that these information requests in 2012 should have put Gemalto on notice of a need to investigate. That's how they phrase it there. Not that they actually provide the information showing a worthwhile claim. Then 9e is the meat of the pleading. And I ask you to look at 9e. This is the material which they plead means that Gemalto has discovered Infineon's cartel practices ahead of the Commission infringement decision. And if you just cast your eye down subparagraphs A to G, you'll see that none of it amounts to anything of any substance whatsoever.
What about the statement of objections?
Well, it refers simply to the announcement of the statement of objections.
Setting out the Commission's concern, they'd agreed to or coordinated their behaviour to keep prices up in the EEA. I mean, you know, this is not, as I say, this is not PC Smith in Streatham Police Station thinking, oh well, there might have been a small traffic infringement. I mean, this is the European Commission saying that it had sent a statement of objections to various suppliers of SCCs, setting out concerns that they'd coordinated their behaviour to keep prices up in the whole European economic area.
My Lord, yes. I draw 2 points.
In a major market.
Yes, I draw 2 points from this. The first is, let's put it slightly differently, apart from the statement of objections, they refer to there being a totality of information, and it's wrong for us to focus on the announcement of the statement of objections. First point is that you see from this that if you strip out that point, there isn't anything else. There's nothing extrinsic to the Commission's investigation itself providing any independent basis for thinking we have a worthwhile damages claim. There hasn't been any suspect events elsewhere. Prices aren't rising. They're doing well in various ways. There's nothing of that kind. So your Lordship's right. The only point is this SO, the fact of the SO. And so we come back to the first question which we've been canvassing since I opened, which is, does that fact mean that they apprehend at that point that a worthwhile damages claim arises?
And it's now 1:05.
My Lord, yes, I will leave it there. I'll just make one conclusion to avoid it being said that I haven't covered this fully. I can't cover all of their pleading, but I should say that in Infineon's statement of case, later on limitation, because they're then asked to put in dedicated statements of case on the limitation issue, they do refine the argument on the relevance of the Commission's information request, which was sent in 2012. So at a later stage, they don't just say it puts you on notice of the need to investigate. They argue as an alternative case that the terms of the information request themselves are such as to mean that there is discovery of Infineon's participation in cartel practices. And so time has started to run. That's the second ground of our appeal. I'm very grateful for your indulgence.
Cheers.
Paul Birss.